succession planning, what you need to know about winding down your practice and transitioning out of the practice of law. Some of the issues that will be considered and that we want to talk about include when is the right time, how to protect your clients, what are the ethical obligations, finding successor counsel, what goes into merging or selling a practice, and malpractice insurance considerations, among other things. Thanks for being with us today. We will have two panel discussions today. The first will go till about 10:15. We'll then take a 15-minute break. We'll come back at 10:30, and we will go till about 11:45 this morning. Our program today has been approved for 3 ethics credits. If you report your credits to the Board of Bar Examiners online, what you want to do is find the button that says Live Webcast. You will find this program in that section. So Live Webcast is the button you're looking for when you apply for credits. During the presentations, if you have a question, you will find a button on your screen that's labeled Ask the Speakers. You can click on that, type in your question or comment. It'll come to us, and our moderator and panelists will be happy to address that for you. The written materials for today can also be found on your screen. There's a button called Handouts. You click on that, excuse me, and you will find the materials. Before we begin, I want to let you know that we have a new succession planning guidebook available to you. This is it. It's called Winding Down: Considerations for Exiting the Practice of Law. This is a publication that was done jointly with WILMIC and the State Bar Senior Lawyers Division. It's a book that will be available on our website on a PDF. If you want a printed copy of this booklet, you can email me at tom.watson@wilmic.com, or you can call 608-824-1700, and we will be happy to get you a copy. Now, for today's program, first panel, we have Michelle Benke to moderate both of our panels today. Michelle is the principal owner of the firm Michelle Benke & Associates, where her practice is focused in the areas of business advising, real estate, and estate planning. Michelle is involved in the American Bar Association, currently serving as the chair of the Commission on Racial and Ethnic Diversity in the Profession. She is past treasurer of the ABA. She has also served on the ABA Board of Governors. Michelle also served as the president of the State Bar in 2004 and 2005, and as treasurer from 1997 to 98. Michelle also served on the WILMIC Board of Directors a while back. Our panelists include Dean Dietrich. Dean is a shareholder with Weld Riley. He has represented clients in the areas of lawyer ethics and professional responsibility for over 40 years. He has represented attorneys in matters before the Wisconsin Supreme Court and the Office of Lawyer Regulation. And Dean consults with law firms and lawyers regarding compliance with the rules of professional conduct. Dean is a member of the ABA's Center for Professional Responsibility and the Association of Professional Responsibility Lawyers. He is a graduate of Marquette University Law School. Dean is also a member of the State Bar's Senior Lawyers Division, and he is a contributing author in WILMIC's Succession Planning Guidebook. Beth Russell earned her law degree from New York's Pace University School of Law, where she served as a member of the Pace Law Review. Beth has been a solo practitioner since the year 2000. She focuses her practice on copyright and trademark as they apply to all industries and also the arts. She is the past chair of the Sports and Entertainment Law section of the State Bar of Wisconsin and a member of the Entertainment, Arts, and Sports Law section of the New York State Bar Association. And our third panelist on the first discussion group this morning is Joe McCarthy. Joe is Vice President of Underwriting and Claims for WILMIC. Joe helps manage the risks of lawyers and helps them understand their insurance coverage with WILMIC. Joe has been with WILMIC since 2011. He was in private practice prior to joining WILMIC, both in Milwaukee and Madison. He practiced primarily in the areas of insurance and civil rights defense. He is a 1993 graduate of UW Law School. He earned his degree, undergraduate degree that is, in criminal justice in 1981 from the University of Wisconsin-Platteville. Joe also is a contributing author in our succession planning guidebook. So with that, I will turn it over to our moderator, Michelle Benke.
Thank you very much, Tom. Good morning, everyone. So we have this wonderful panel, and we're going to start talking about transitioning practice. WILMIC sponsored a program similar to this a few years back, and in fact, Beth and I both attended that seminar. And we were sitting in the room, and kind of there were these sideward glances. It's like, okay, there's a code of silence, right? I'm not going to say that you were here. You are not going to say that I was here. But since COVID, I would say lots of people are thinking about transitioning practice, not only because, hey, life has been interesting and challenging over the last 18 months to 2 years. But people were also thinking, hey, what happened if I were sick? Or what would my clients do if I were not available? And so transitioning practice has come to be at the forefront of lots of people's minds for lots of different reasons. So let's kick off the discussion today. When people start to think about transitioning, there are lots of things that go into that. And Dean, I'm going to throw it to you first. What are some of the biggest issues that lawyers are considering when they're thinking about transitioning their practice?
Thanks, Michelle. Unfortunately, that always has two answers to it.
Yeah.
One of the most important things that lawyers think about when they're considering transitioning or considering a movement into a phase down in their law practice is, what am I going to do? My whole life is focused around helping people. My whole life is focused around being in the office and taking care of business and billing people and all of those things. But that's really not the right question. The real question is, how much do you trust yourself? Because everybody that I talk to, both lawyers and non-lawyers, that have decided to transition into some sort of a retirement capacity are busier than when they were practicing law. And the question becomes, how much do you trust yourself that you will be busy, that you will do things, or that you will contribute back into the community? And that becomes really the real hard aspect of transitioning, if you're kind of transitioning into a place of being out of the practice. The pandemic has changed things, Michelle, as you suggest. I see a lot more lawyers talking about transitioning. They've had enough, if you will, of dealing with the technology. I've seen and talked to others who are looking for where they want to place their practice. Mm-hmm. And I'm one of those people. I've transitioned from a big firm to a very small firm, now back to a medium-sized firm. And part of my considerations in that transition was finding a landing point, mm-hmm. a landing place for me and for my practices. And Michelle, maybe we'll talk some more about that.
Absolutely. And you've kind of touched on another point that I think people often, as they're thinking about transitioning, if you're in a large law firm, that transition might be pretty easy. There might be some younger associates, and it's really more a matter of matching files and lawyers that are in the practice. I'm a solo practitioner. Beth, you're a solo practitioner. That transition thought, I think, goes a little bit different. Can you talk to us a little bit about the thought process as you see it from not only a solo perspective, but as someone who has a more specialized practice, copyright and trademark protection?
Sure. Thanks, Michelle. I think before I answer that particular question, I want to put us in a little bit of context in that I wondered at first why was I asked to participate today. I'm probably within the 10-year window of transitioning out of my practice, and that being the case, I haven't done this, so I don't have answers about how it's done. I have lots of questions, and it became clear as I talked with Tom back and forth that I'm probably here to be a voice for everyone else out there in a similar circumstance who has tons of questions. And maybe I can voice them and let everyone else know that you're not alone. We're all kind of in this same boat together, and maybe today will be our first step in starting the process. But to your question, Michelle, there are two factors for me. One, you mentioned, and that's the mere fact of being a solo. And this, one of my challenges is not unique to my practice area. It's probably something that all solos face, and that is the time constraints and the challenges of mentoring a younger attorney to learn your practice, to learn what you do. In a larger firm, that's the culture, that's what happens, and there are the resources for that. As a solo, I don't have that luxury. It takes a lot of time to be a good mentor and to prepare someone to learn the skills and become competent in the practice areas. And in fact, I've tried it several times and with very little success because it took double the time. And as a solo, I couldn't afford that time. I couldn't afford to do things twice. So that's the thing. When I think about who's going to take over my solo practice, I start with, kind of a wide funnel. It has to be someone younger and all right, that's not such a problem. We got lots of those. But then, it's someone that I did not have time to mentor. So I have to find someone who has existing expertise in my areas. That narrows the funnel a little. As you mentioned, mine is a somewhat specialized practice, but still there are practitioners in larger firms that do what I do and that have the expertise. They exist, but now let's continue to narrow the funnel. And the next thing is they have to want to be a solo, and now we're closing the gates, because if those eligible candidates come from big firms, the likelihood of them wanting to make that drastic of a change in culture and especially in income is small. So my funnel's getting narrower and narrower. And the answer to your question is that's my challenge, is finding a suitable person to take over. Another thing that is unique to my practice, especially in trademark, is that I have established a pretty large network of foreign counsel relationships. I have to do that for clients who are either in foreign countries or do business in foreign countries. I have a big network now, and if someone takes over my practice and I'll introduce them, but if they don't maintain those relationships or establish their own, their pipeline of business is not going to be what mine was.
Terrific. So more things to think about. Dean, you started out and you touched on this. For some lawyers, they want to go out with their boots on, having the clerk of court stamp their filings on the way out the door. Beth, you talked about a window, kind of preparing for this. Can both of you maybe chime in on some of both the emotional and the practical points of planning for that transition, either things that keep you from planning or stumbling blocks as you're trying to plan? Dean, I'll start with you.
Sure. The watchword that I would start with is you can't start planning any sooner. I mean, you have to start as soon as you possibly can. And a lot of that turns on your kind of mental focus. I have to confess, I think I'm pretty poor at planning. I was commenting earlier, I've had some medical conditions that most people would start to think about, hey, it's time to move on. In fact, some of my partners thought I was moving on when I left to open my own law firm. It is a mental strain to come to grips with how do you realize that at some point you have to continue to be caring for your clients, but you also have to care for yourself. And quite often we haven't trained ourselves in how we've represented our clients. Getting up at 4 a.m. and communicating with my clients because I know they're anxious to get something that day. That's always been kind of the mindset. Maybe thinking that I shouldn't get up at 4 a.m. because it's harming my health is a hard transition to make. And I've been struggling for the last 5 years with trying to figure out where do I really want to go and at what point do I want to move on to other things. And as I said, everybody says, well, you're not going to know what to do, Dean. And the reality is I got plenty of stuff I could do without having to worry about clients. I don't have a real good answer. I do believe there are 2 steps. 1, start early. 2, talk to people. Nobody has a blanket answer to how do you transition yourself, how do you make changes that are going to feel good for you, but talk to people. Because you get pieces and bits from different people that help you figure out where you want to go and your timing. I'm not in a big hurry, but others are very interested in moving quickly to enjoy other aspects of their life.
Beth, I'll turn to you. Same question. What are some of the either impediments or issues that you see as stumbling blocks or things that make it easier for you or others that are similarly situated to put off transition planning?
Two things come to mind. One is, let's face it, in the last couple of years, we have all been through the ringer in one way or another, no exceptions. And on top of the other pressures of managing a law practice and doing the work and all the pressures that we feel every day, I think we feel a little bit paralyzed. And again, I'm speaking for people in my situation in this window where planning needs to begin, where I feel like I'm in quicksand. It's like I would, the greatest gift to me today would be if someone were to give me one tangible step that I can take today to move this train forward. Now, of course, being here is part of that, but I'm not really going with that one because we go to a lot of seminars, we get great ideas, we get all jazzed up, and then go home and don't do anything. I want an action step today. It's like, you know what? Today, this is what you do. That would help a lot. A completely different sort of emotional challenge is, again, for a solo practitioner or small firm too, is our financial issues. In my particular case, I have no other source of income now, and I won't in retirement other than Social Security. So everything I have will depend on what I have saved and what I continue to. Is that enough? What do I need? What's that actual number? And I'll tell you, I realize I have found out what my number is, but I only recently found out, like in the past 6 months, have I known this number. And I wish I had figured out that number like a lot earlier because it would have informed some decisions that I've made. But financial pressures are huge. And to the extent that people can work with advisors and again, it's get specifics. I think the more we have in specifics, whether it's in action steps, financial numbers, whatever, we just feel better.
Just Michelle, if I could, I've talked with a lot of different lawyers about that finance number. And my impression is that many lawyers feel they need to keep working because they can't afford to retire or to transition to a very reduced type of practice. And by the way, later we'll maybe talk about the difference between those two. So it's very wise to start at even a younger age, Elizabeth, to figure out, are you doing the right things from an investment perspective, and everybody's different. Everybody has different views about that. But the one magic recommendation I would have, although I didn't follow it, is spend the time to figure out when is the date. What is the date that you really want to comply with, where you're going to transition either to a very limited practice or no practice, and then stick to it. I know I haven't done that, but the more you can set the date and then work towards it, the better you're going to be. And there's a lot of lawyers out there that are smart enough to do that, and they say this is the day that I want to transition out of my practice, either transfer it to somebody else or find somebody to take it over, that type of thing. But find the date, and that's and you're never too young to start thinking about that date and trying to set that date and live with it.
But Dean, don't you have to have a master plan before you can set the date? For example, if my plan was to shut the door, that's one date. If my plan is to merge into an existing firm, that's a different date.
Yeah, and I probably haven't been specific enough here. I mean, setting the date means the date you're going to do something and what you're going to do, and deciding that. In some of my transitions, I had outside forces influencing my transition, so I can't say that I followed a deliberate plan. You know, that's not unusual either. I mean, we're all trained to be flexible. But setting a date also means this is the right plan for me. And again, talking to people.
I'm going to interject here, and then I see Joe's got something. The actionable plan, Beth, that you talked about, I think this is a good starting point. If you sit down and read this, like we all have so much extra time, but in preparing for this panel discussion, and I opened it up and I was like, yeah, whatever. And, transitioning your law practice, when do you know it's the right time? I mean, I think that's a great beginning because to Dean's point, what are you thinking about? Is it transitioning into limited practice? Is it shutting the door? Is it becoming of counsel someplace? And when I first started thinking about these kinds of issues, I wasn't sure what transition meant. Joe?
So what I hear a lot in talking with our policyholders and other folks who call and want to talk about issues like this as well as some other things, it's interesting for me, there's been a couple of dates that stand out each year. July 1st and the end of the calendar year. And so many times that lawyer I'm talking to are like, look, I'm done at the end of the year for tax reasons, wrap up my business sorts of reasons. End of the calendar year makes a lot of sense. Surprisingly, the other piece is I don't want to pay dues for the next year, so July 1 is going to be the day. And so I think that people do pick dates. I won't say they're artificial dates, but there are dates out there that people pick. And my sense has been a little bit that folks pick that date and say, okay, now I really got to put together a plan. The first time that I was involved in talking about this subject was a couple years ago at Senior Lawyers Division seminar. And room full of folks, I was surprised by the number of people at that conference that had said, yep, I started this 2 years ago. And they really had done some deliberate thinking and put together a plan. Was it perfect? Who knows, right? But they had a plan, and they sort of stuck to it, and they were moving forward. And the discussions I had that day, I came away feeling a lot better about people out there because, like, okay, they are paying attention. They are, really trying to plan for this. So
terrific.
Yeah.
One of the things that I think might impact people's ability to either pick a date or pick what the transition looks like is clients. Most all of us got into the practice of law to help people in one way or another, and you generally speaking, like your clients, generally speaking, want to help your clients, and generally speaking, know the things that your clients might need. And so as you think of transitioning, either taking yourself completely out of practice or selling your practice to someone else or merging your practice into another firm, one can't help but think about how that might affect the clients. Beth, let's start with you and your specialized practice. What are your thoughts, or what are the questions that pop into your head as you think of how your clients would navigate your transition?
My first thought is that when we refer to our clients, it's not necessarily, a homogeneous group. We have, in my transactional practice, I have clients that I will do a single job for, and that's one category. And transition for them is not as great a concern. Certainly, my practice is very deadline driven, and deadlines in trademark especially can, go out 30 years or forever in some cases. So, advising them and making sure that they know about deadlines is one thing, but for a one-off job, that's not such a big deal. For other clients, companies in particular that I've been working with for years and years and years, and we're a very important match. Those are the clients that I worry about. Mm-hmm. They work with me because we are a good match. They are not necessarily for a large firm, and it's worked for a long time. I feel an obligation to those types of clients that probably goes beyond ethics and the rules. I mean, it's personal values. We've established a relationship, and I don't want to betray them. You used that word, Michelle, earlier, and I agree with it. It feels in part like a betrayal. So anyway, it helps me in a way to separate those types of clients, the one from another, because it's a little less overwhelming. It's like if I take all of my clients, like, holy cow, that's a lot. What am I going to do with all of these? But if I break them down into the ones where I have the really meaningful relationships and focus there, it's a more manageable chunk to deal with.
And Dean, I'm gonna pop over to you because you have made a couple of transitions. What were the thought process? What was the thought process? What was the work that you had to do in thinking about what happens with your clients, and how you discuss that transition with your clients?
It was certainly something that weighed very heavily as I looked at some transitions, and quite frankly, I don't know how to not think about and put the client first. And I think at some point in time, I have to come to grips with that. In both of my transfers, both of my transitions, which were significant moves, all my clients came with me. So it wasn't that we had to talk about it very much, but it created this huge loyalty on my part that all these clients came with me. And I know in the midst of the pandemic back in fall of 2020, for the first time I thought differently. The reality is the clients will be okay in the end, but at some point you got to transition to say clients are important, but I'm important too. I'm really not able to get to that point yet, and I want to be there when my client calls. Some of them I've been representing for 40, 45 years, and I can help them get through their problems pretty quickly. So, Michelle, I haven't found a good answer to that. I haven't found a good way, and I was pretty fortunate. Like you, Beth, my practice was pretty narrow, and therefore the clients would come to me instead of having other options, which makes it a little easier. But it is a challenge because I've spent 45 years helping them. And to now suggest that maybe that's not as important is really hard to get beyond. Really hard to get beyond.
And probably harder for the lawyer than the client, perhaps.
I think so.
Yes.
I think so.
We have a question from the audience, Tom.
Yeah, more of a comment with maybe a follow-up question, Michelle. The viewer writes he's a solo practitioner with a specialized practice. He could not find a suitable successor, so he pretty much wound down the business with help and input from his clients. He says it was actually much better for him than trying to deal with a successor. And he wasn't worried about the money, he said, so that was not a big deal. He said it was appreciated by the clients and it let him get on with the next phase of his life. He says his former clients are still his friends. So his solution, I guess, was I'll just wind it down. I'll work with my clients, as I think you're suggesting too, Dean, in that respect. And the viewer is wondering, any thoughts on those options and whether that makes some sense.
The most important comment I would make to that is the clients really appreciate it when you go to them and work with them to transition, to identify what your plans are, to help them find some successor counsel. I know a couple of lawyers that have transitioned quite a bit of their practice, but still keep practicing for a couple of clients. And that is a way for them to wind down. So I think it's a very important point that the clients really appreciate it. They really want to work with you. And I think clients, much as we don't believe it, clients understand that as we progress in years, that they may have to find somebody else.
I'll jump in here with a little personal side note, and then I will run down the rest of the panel. As I have taken on various bar activities, not a full transition of practice, but I have gone to clients to say, I am undertaking X role within the state bar or X role within the ABA, which will reduce the amount of time that I have available to do client matters. And the first thing that clients say is, I really appreciate your telling me that. Mm-hmm. Great, we're on board. The second thing they say is, but you'll still be helping me, right? so that transition that they're talking about, that transition and understanding that they fully understand needs to happen, they think it applies to everybody else and not them. And when you have represented people for a number of years, figuring out which ones that applies to starts to get a little dicey. Beth, you want to chime in on the viewers' comments and Dean's comments?
Well, as to the viewer, I would say that viewer should probably be the one sitting here. I mean, he's been through it.
Yeah.
I mean, when Tom asked me to do this, the thing that showed me that I was actually old enough to be doing this was my first thought was I Love Lucy. And, Lucy wrote a story and it was accepted for publication and she was so happy. And then when the book came out, it was in the chapter called Don't Let This Happen to You. And that's kind of how I feel here. So I'd say that viewer is informing us. And again, to prove that I'm old enough to doing this, I had a excellent response to your comment that I now can't remember.
Well, it'll come back to you, and then
it will.
So Joe, we've talked about the book that WILMIC has put out. If somebody's thinking about this and they go to clients and they start talking to clients, should they also pick up the phone and call their professional liability insurance carrier to either let them know that transition is happening or to talk about what is the role or could the role be of the professional liability insurance carrier?
Well, I recommend that you do that, and I encourage all of our policyholders when we're out and talking about it and they come up to me, it's please give me a call. We'll talk through whatever questions you have. Hopefully I can answer them. If I can't answer them, I'll try to get you to the right person. The beginnings of the book that Tom has put together on the transitioning, I think you're right. It's a great start, and it's the first time we've had something in our hands that we can hand to folks. But I think that on top of that, as Dean mentioned, talking to all those people around that you've seen go through this too. Because they will give you insight and experiences that, as you're finding out, Beth, no one else has until you actually go through them, right? So the more you communicate with people, talk with us, talk with the folks here at the State Bar, there are resources out there that you can lay your hands on and conversations that you can have to help you through some of those things. And listening to your comments about clients and communicating to them, one of the overarching things that we see in claims at WILMIC is if you communicate more clearly and more directly and more consistently with your clients, you eliminate a lot of problems. Mm-hmm. So the more you communicate, you open those doors, they feel like they're part of the process. Mm-hmm. Some of the insight and knowledge that you folks have for individual clients that you've been working with for years, you'll never be able to replicate all that knowledge and hand to someone else, unless you're literally writing it down, right? You know how your clients are going to react to certain things, and you know the sound of their voice. Oh, they're not happy, right? The next person won't pick up on those subtle hints. So the more you talk to people, the more you communicate with your clients, maybe you'll find out that what you think is so important, the client doesn't think it. They have a different list of important things, right? So I think opening the door and allowing them to be part of it, get them involved in the beginnings of that transition can really help. And I think the gentleman who had the question, I think that sort of points that out.
Dean?
A couple of things. First of all, various malpractice insurance companies view transitioning different. It's not all the same, and so you need to spend a time checking out what your current plan does and how it handles things. I've been surprised at some of the differences, ranging from buying some sort of tail coverage to giving you tail coverage. So it is all a little bit all over the ballpark, but it is clearly something you want to resolve quickly and early, so it's not a worry. In 99% of the cases, there's not going to be a need for the coverage, but it shouldn't be something that you're worried about. You should have that coverage set, determined, understood, because you're going to be looking to figure out kind of where you fit, where are you fitting now in the legal community, in the local community, in your professional studies, in your professional views. Those are going to be challenging issues, whether it's transitioning to a lesser active practice or transitioning out of the practice of law. I have to confess I'm jealous of lawyers that are able to say, at this point in time, I'm going to walk away from the practice of law. I'm jealous of that. I'm amazed that they can do that. And I think it's important that they know and figured out that that's how they have to do it. But it's going to be a challenge for everyone as you look at this issue. My belief, Beth, is younger lawyers, and you, in my view, fit under that category, have a little better view of where their priorities should be. For those my age, and that's just a lot of years. That's all I'm going to say. It's hard to figure out exactly where your priorities are.
So let's stay on this issue of kind of malpractice, professional liability insurance a little bit, because I think that is an important point and, one that, again, without fully understanding it, could be a stumbling block for lots of lawyers. They don't know what it is they would have to do, and so they just avoid it. I'll just keep practicing. So that's going to be an impediment to transitioning. I have a very good friend who transitioned out of practice. And being a solo, I was in the midst of a really huge transaction. And the law firm on the other side had a senior partner, a junior partner, an associate, and a paralegal. And they were shooting me emails left, right, and center. I thought I was going to die, right? So I reached out to this friend of mine who was also a transaction. I said, hey, wouldn't you just love to come and help me like for 3 weeks? And he said, oh, no, I would not. And more importantly, the tail coverage that I have says, not even a little bit. So can we talk a little bit about tail coverage, what it is, Dean, you said you might not need it. My hair stood on end. Can we talk a little bit about what it is you're doing to protect both your clients and your personal financial well-being with malpractice insurance? And I'm going to start with you, Joe, and then we'll work our way back this direction.
I think the first hurdle to get over on with this question of malpractice insurance is understanding the difference between, or understanding what kind of insurance it is. Mm-hmm. So we talk about claims-made policies all the time. As far as I know, all the professional liability policies out there covering lawyers nowadays are claims-made policies. It's different from your homeowners or your auto insurance. Those are occurrence policies, and the policy that's in place at the time that an accident happened or that an occurrence happens, that policy will cover that occurrence, that incident. Claims-made policies are different in that you have to have a policy of insurance in place at the time your client makes a claim. So if you did work for someone 2 or 3 years ago, they realize that, oh boy, we need to check this out and make sure that that's not really a mistake. There might be a claim here. When that claim is reported to your insurance company, that's the policy that's going to take care of that claim for the work that you did 2 or 3 years ago. So that's the big difference. And that's where tail insurance comes into play, or sometimes you'll hear the term prior acts coverage. Mm-hmm. So anytime a lawyer transitions from job to job, from a solo practice to going into a firm, or from a firm going out into solo practice, you need to figure out, how do I continue to insure that work that I've been doing? When with bigger companies, they have policy language that extends that policy's coverage for that lawyer when they leave the firm. And it talks about they continue to cover the lawyers as long as they were doing work for the firm and it was all within, the terms and conditions of that policy. So as lawyers transition away from a firm and go out into their own practice, it may be that you don't have to buy tail coverage. That policy continues to cover that lawyer after they leave the firm. I think administratively, it's just easier for bigger companies to say, we're going to cover that. And particularly, look, the client that you were doing work for was a client of the firm. So the work was all there. It sort of makes sense if you think through it. I remember the very first time I went out and spoke in public with Tom. We were up in the northwest corner of the state, and somebody asked me, why do you charge us for tail endorsements? I was like, I don't know, but I'm going to figure that out. And I came away thinking, Tom and I talked about it on the drive home, and over the last 10 years, I've been thinking about it. And look, there aren't a lot of companies that give away insurance for free. So I always think, okay, you're paying for that on the front end somehow. With us, we just do it a little bit differently. So when you retire, and that's the focus here today, is let's talk about that. When you turn off the lights and walk away, and you're comfortable that you're all done practicing law, then you can buy what's called a tail endorsement. They're not standalone policies. It's an endorsement that attaches to the last policy that you had in place while you were actively practicing. And it simply opens up a window of time into the future within which somebody can come forward and make a claim. So when I said you have to have insurance in place at the time the claim is made, that tail endorsement stretches that policy out into the future, and that policy will be in place when somebody comes forward and make a claim. A lot of companies offer unlimited coverage. Our tail endorsement, the ultimate is unlimited, so that tail coverage is there forever, theoretically. So you can sleep at night knowing that we've not only protected yourself, but you're also protecting your client. I mean, the one thing that we talk to, especially young lawyers all the time about, why should I have a policy? Well, because people do make mistakes. You know, you probably will make a mistake at some point in your career. And if
This
that
is where we all knock wood. Not,
right.
go ahead.
And if if your heart's in the right place, you really want to protect the well-being of your client. If they lose out because of some mistake you've made, then your insurance policy can come in and help make them whole and put things back together. But I think that as lawyers are thinking about tail coverage, there's two pieces of advice. Call your carrier and read your policy. And if you can't figure it out, you can call us. I'll help you try to figure it out, So it's not the easiest thing to wrap your head around. So the more you talk to people, if you're insured by us, the more you talk to the folks at our office, hopefully the more you'll understand. And I think that goes the same for other carriers. Earlier we talked about what insurance companies can do for you. I talked to folks who transitioned from one carrier to another, and they talk about, well, I was constantly taking continuing education or risk management classes from my last carrier. So if you're out there, your carrier can be a resource for you to reach out to and help you figure out some of the answers to some of these questions.
Dean, I'm going to jump over to you. You've made a couple of transitions. How actively engaged were you in having these discussions and figuring out what your coverage was? As Joe described it, it's prior acts coverage. Can you share some thoughts and ideas?
I certainly can. In my first transition, I went into a new firm with a new set of insurance coverage, and I felt kind of comfortable that the actions that I had taken in the old firm were going to be covered. So I wasn't as concerned about prior acts coverage. Now, as I've transitioned to another firm, I was much more concerned because I was in a small firm, almost like a solo practitioner. And you need to be very concerned. A period of time, 6 years is the statute of limitations for most claims. So you got to be concerned about that. In this particular case, the new carrier basically said they're going to cover it. They're going to pick up those 3 years and provide protection. That doesn't happen all the time. So that's why you got to be checking with your carrier. I'm talking with a gentleman right now who's has his license, but he's really closed his office. He's not active, but he serves on various community boards. And what's the first thing that they ask you when you're on a community board? Well, what do you think, Beth, about this from a lawyer's perspective? Whoa, wait a minute. I'm not practicing. I'm not your lawyer. Real hard to say that. Real hard to get people to buy into that. So there's a concern about, is there coverage for those types of activities and whether or not a mistake is made in giving that kind of offhand comment. And that's why I think it's really important to pay attention to it. As I said earlier, I want to get that resolved right away so I don't have to worry about that as I'm making my transition, because I got all sorts of business considerations and everything else to be thinking about. So you got to take the time to understand it and make sure you have coverage. And as you both say, it protects your client as well.
Beth, you said giving voice to the questions and issues. So Joe explained what prior acts coverage does for you and your clients, and Dean talked a little bit about some of his experiences. What questions or issues does that raise for you?
Both the viewer who we heard from earlier and Dean have both mentioned continuing to do some work for a few clients. So our discussion so far seems to have been shutting the door and stopping practice. But I'm wondering what it means insurance-wise if we're just cutting back. Is that a time to call our carrier and discuss some different kind of policy, or more limitations, or not?
No, that's all fair questions, and those are the kinds of discussions I have every day. So I think that reaching out to your carrier and talking through is going to at least make you feel better, and it's going to educate you to some extent. But I think that what people need to realize, if you're transitioning away and you're slowing down, talk to your company about rating you on a part-time basis rather than full-time. As we try real hard to put the correct premium on whatever risk is out there. And if it's a firm with a couple of folks that are, full-time and going real hard, and then one of the elder lawyers starts to slow down, we want to know that individual. Every person in the firm, are they working part-time? They working full-time? So same thing with a solo practice. If you are slowing down, talk to your carrier about that, and then hopefully get the right premium attached to that risk, because it is less risk because just the amount of work you're doing is not the same as full time. The other thing that I think about as we talk through these things is, if you retire and you buy a tail endorsement, it's going to cover all the work that you already have done. It's not going to cover anything new or anything ongoing. So that I'm almost afraid to look some days at what the percentage is of part-time lawyers that we insure. But there's a lot of folks out there who are going through that transition, and they go through it for, anywhere from 3 to 6 years. You can see them slowing down, and each year there's less hours, on their policy or on their application. So we try to apply the right premium for that, and I think that's a decent way. A decent reflection of what you're actually doing, and a decent way to do it. Because I think anyway, there aren't very many lawyers that just say, I'm done, turn off the lights and just walk away. We're all too, embedded in our work, and we care about what we're doing, that folks don't do that. But I do see a lot of people going from full-time to part-time and sort of slowing down through that method.
Joe, do you tie if somebody goes inactive on their license versus keeping their license active, is that kind of a marker to look at? Because I think a lot of people consider themselves inactive but keep their license, and that could be a risk.
Yeah, no, that is a hurdle for us. It has to be an active license. If somebody goes inactive, then I talk to them about, we can't insure you anymore. You don't have a license to practice. And actually, I have kind of a funny story. A couple of years ago, when we were in Eau Claire doing this, a guy came up to me and he said, "You gave me the best advice anybody's given me on this." And I'm like, "Where are my bosses? They need to hear this. I actually gave some good advice." And he said, "No." He said, I called you and talking through some things. And he said, "Okay, what if I go to church and I'm coming out and somebody says, 'Hey, Dean, I need you to do some work for me.' He said, 'You told me, tell them I don't have a license anymore and I can't practice.'" I said, "I've heard that from other people. Maybe that'll work." And he said it worked perfectly for him in that situation. But he had clearly also, I'll go back and hit on some of the things we've already talked about. He clearly had communicated to all his clients, "I'm backing away." So everybody knew in his little community, everybody knew his transition was going on. Yeah.
So it sounds for two of our discussions that it's having ongoing discussions, both with your clients, as Dean pointed out, in terms of transition, and with your carrier. Yeah. It's not one conversation. I'm hearing that we have several.
Yeah, I think that's right.
Yeah, I think that's true, especially if you're, and I think most lawyers are looking to do this, to phase back their practice before they close or walk away from their practice. And that's its own transition, and that's its own obligation of communication with clients. Clients want to know what's going on. And it's also a way for you to make sure you've got proper coverage. There's a lot of dispute and disagreement over, how much should you communicate to your client? How much should you tell your client? I had some health issues a couple of years ago, 4 years ago, 5. I told everybody. I'm not gonna hide that, first of all. Secondly, I don't want somebody to hear it. It had nothing to do necessarily with ethics, but it had to do with I didn't want somebody to hear that from somebody else, one of my clients, and then call me up and say, "Hey, Dean, I heard you just had a stroke. What's going on?" That's the worst thing that can happen from what I call PR perspective. So communication with clients, I think, is critical, and the relationship you should have with your clients would make you comfortable having those communications.
I think we have a question from our audience.
Yeah, actually two, Michelle. These are follow-ups to what you've been discussing. This one's for you, Joe. When you were talking about tails, the question is, and we get this all the time, so I know Joe is ready for this because we hear it. How should you decide how long a tail policy you should purchase?
What I tell some people is look at the price you've got for each length of time and sort of, see what you're comfortable with. But I always tell them as well, how much you've been working and how much risk is out there. No one knows your book of business better than you do. So rely on your instincts, your gut check, if you will. I think that if I had been out there practicing all this time in private practice and I was going to retire, I think I would spend the money and buy unlimited coverage. And I tell people that more often than not. I think I would I'd sleep better, and I'd be more confident that my clients are going to be protected, down the road. Now, I also tell people every area of practice has a little bit different shelf life in terms of when claims come forward. Anecdotally, the vast majority of the claims that we see come into the office probably within a year of the work being done. Once you get out several years, it drops off pretty dramatically and pretty rapidly. But we have claims that are, come to light 20 plus years after the fact, when somebody realizes that a real estate document was incorrectly drafted when a sales takes place or something like that. So that shelf life of your area of practice, the sorts of things that you have to think about every day, you should be thinking about when you're buying tail coverage and for how long you need it, because, the statute of limitations for claims is subject to the discovery rule. So it really matters when your client knew or should have known that a mistake was made. So that's how the shelf life of some areas of practice gets stretched out well beyond the statute of limitations.
Well, I'll interject here to say I've heard that before, and unfortunately, I practice in both real estate and estate planning, so I think the decision was made for me. It's going to be unlimited. Second question?
Well, and before I give you the second question, I should mention, Dean, you said the statute of limitations is 6 years. It actually is 3. It was changed in 2018. So,
but it's still the discovery.
It's subject to the discovery rule. That's right. Next question from the viewer. Dean mentioned being asked questions after you end your practice. One attorney I heard say when contacted by old clients or friends for basic advice, he would say, "I am not practicing now, but when I was practicing, I would have told you A, B, and C." The question is, how dangerous is that?
I'm nervous. I'm shaking a little bit here. It's interesting. I mean, there's a theory that if you're just talking about general legal principles, you're not really engaged in the practice of law. I don't like relying upon that theory very much, but the connection that particular lawyer made truly puts you into a category where he's now providing legal advice, and that's a problem.
I think there's an inherent conflict, by the way, of lawyers and their service on boards. If someone asks me to be on a nonprofit board, I will say, is it because you want my contribution because of my relationship to your mission or for some other reason? Because if you want me to be a lawyer, I'm not going to be on your board. I'll be your lawyer. but I'm not going to be both.
That's a consideration, and we talk about it in the ethics rules. I mean, the way to avoid it is to be very specific. I'm coming on board. I'm not your lawyer. When you're asked questions from a legal perspective, you make clear that you're not answering those questions as the lawyer, and you avoid answering the questions. I like to tell the story that you should wear two hats. You should bring two hats to the meeting, your lawyer hat and your white community member hat. But the problem I have, Beth, with that, and the struggle I have with that is we can contribute a lot to the community, to the organizations that are in your community, and so I like to encourage community involvement with the proviso that you got to be very clear that you're not being their lawyer. And I know when I began my involvement with a local healthcare organization, I didn't send a letter in saying I'm not going to be your lawyer, but I made it very clear to the CEO that that was the role I was going to take. And you just have to be cautious.
We have another question from our viewers.
Yeah, another question. Transitioning from active practice to retirement and acquiring a tail, is it permissible under the tail to act as a mediator in a manner where the parties have counsel, in a manner where the parties are pro se?
No. I mean, your insurance policy is not going to cover you because it's work being done. If you're going to say, well, I'm somehow practicing law as a mediator and I want to be covered by insurance, if your tail endorsement is already in place, that's the date that it won't cover any more active work after the day it goes in place, basically.
Yeah,
So.
and there's, if you've tendered your license, so you're, quote, inactive in the eyes of the court, in the eyes of the Bar Association, but you're engaging in mediation services, there's a huge debate because the definition of practice of law in Chapter 23 excludes mediation. But what's not written in that rule is mediation being done by a lawyer, even though they've declared themselves to be inactive. That's an uncharted area in our rules, and I would be the first to say I'd be nervous about that I would really question whether you'd still be covered under the ethics rules, even though you've tendered your license, you're inactive, but you're doing what appears to be a law practice, even though the definition says it's not. It's a real gray area.
Joe, what happens if we change our mind? And we've got a tail endorsement in place. We still have our license, and we decide, I want to go back and start practicing again.
We've had people do that. Maybe more often, folks come off of the bench and go back into private practice. They don't run for re-election or they lose their election. And then they go back into private practice. The way we approach it is we give you what's called a retroactive date. So let's say you came off the bench and you want to start practicing again April 1st. We'd put in a retroactive date that says WILMIC is going to start covering you on April 1st, and then that policy will go forward. The benefit to the company is, and whether it's us or some other carrier, they'd probably approach it the same way. It's a pretty common approach. The benefit to the company is they don't have to worry about anything you've done in the past, and particularly if you've not been practicing for a short period of time or even a couple of years. There's no need to pay for insurance because there hasn't been any work going on. The benefit to the policyholder is you pay a fraction of the premium, and then with most carriers, over the first several years, your premium builds up a little bit each year until you get to 100%, until you're fully active again.
But what happened to that tail endorsement I had for what I did for the previous 30 years?
You need to be careful about that. Some of the carriers where there's an automatic tail, if you go back into private practice, getting another insurance policy can wipe away that tail. With WILMICs, that endorsement stays in place. We wrap it up in a box and put all that practice over there on the shelf, and that policy that you had in place at the time, you were actively practicing, that's going to cover all the work that you did when you bought the tail endorsement. So.
We only have a few minutes left, about 10 minutes left, which is probably not enough time to really delve into this. But we've been talking about transition as a very voluntary decision, either walking out the door, moving to another practice, that kind of thing. Something for which this book would be helpful and useful. But what about the involuntary? Lots of people, it kind of hit them in the face as we started down this pandemic. You can't plan for when you might be ill to the point of not being able to practice or pass away. What are the kinds of things that lawyers ought to be thinking about in terms of that transition in practice, and how are they similar or different from the voluntary transition in practice?
Well, there's a couple of thoughts first before we dig into those. Another type of involuntary transition is when a firm dissolves, and I've had that a couple of times. Yeah, and you there have to be very concerned about tail coverage, prior acts coverage in one way or another, in order to protect yourself for that. But the whole issue of the pandemic and how it's affected people's thought, and we probably all know of people, of lawyers who have suffered serious illness, if not death, in those circumstances. And it starts from the perspective of thinking about it. What are you going to do under those circumstances? And B, either are you going to find somebody who could assist the family in taking care of the business of the firm, or there is a procedure for a court appointment of a lawyer, typically a lawyer, to be assigned the responsibility to kind of, quote, wind down the practice. I don't want to get in a lot to the whole notion of the sale of practice, but recently had a couple of situations where that happened, and because of the death of the lawyer, the sale works. There's particular rules you have to follow, but it's a burden on the family. It's a burden on the spouse, and so you need to have some thoughts about how you're going to address that, how you're going to take care of it. I think, Beth, you've kind of addressed some of that after the session in 2019.
Yeah, it occurred to me, thinking about today, that thanks to WILMIC and the State Bar, I did the work to put a disaster plan in place. I have a successor attorney. I've done that work, and that was a big project. And I will share with you that my mistake probably was I thought, all right, good, I'm good. I did that. And then it occurred to me that that's just for disaster. It's not for voluntary transition. I have a whole new giant project to do again. It's like, all right, not the best, but at least I realized that they're not the same.
But you've addressed one issue.
Yeah.
Michelle, another area that I've seen is situations where the lawyer is perhaps suffering from some disabling conditions, and others in the office see it and are aware of it, and the best advice that I can give for that is to contact the State Bar WISLAP program, because we have in fact broadened WISLAP and developed a group of lawyers that are able to come out and assist that lawyer in addressing the challenges that are faced with some of the diseases that impact mental capabilities.
Joe, you want to chime in on
Sure.
the involuntary?
Yeah, some of the most heart-tugging stories are that phone call that you get from somebody who says, my husband or my wife has passed away. I have no idea what to do with their law practice. I'm sitting here staring at these files. And then we talk to them about reaching out to WISLAP and whoever else can help, obviously. But I think the overarching message here is create a plan. Unfortunately, it's more than one plan, as you know, but there are decent checklists that you can find to say, boy, I need to check all these things off so that if I get hit by a bus tomorrow, that lawyer down the street who's going to come and help me out, they know where everything is. They know, I've given them all the information. So there are resources out there available that will give you a head start on some of this stuff, but it can be as simple as you're sitting thinking about something, write it down on a piece of paper or a napkin, because I've written down probably 15 things that I was going to say as you guys were talking, make a point of this. But that's how you can start a plan. You just like, oh, I never thought about that. Start writing those things down, and eventually you have your own outline. And if you use some of those resources that are out there, you will start checking all the boxes on those lists.
And I'd say share it. I say in my engagement letter now, contact the State Bar of Wisconsin for information about my successor attorney. I don't say who it is, but I say contact the State Bar.
Wow.
And there's a service. The State Bar has a service that they provide that allows you to set up that successorship plan. And I think WILMIC has a book on the what happens in that disaster situation.
And the contact information for that state bar program you're talking about is in the appendix of the book.
Great.
I thought I had the perfect disaster recovery plan because my husband is also a lawyer, also bound by the same ethical obligations. And I did put together the plan, and I sat down with him and I said, here's the plan. And then keys to certain things are here, and passwords, can be accessed in this methodology. He looked at me and said, nope, you die, I'm locking the door and walking away, which told me I needed to redo my plan. My plan was not foolproof. We have another question.
Yeah, another comment from a viewer, Michelle. This is, it goes like this. I've been thinking about this for a while now, and one of my fears is that I will not be able to make a clean break. I've been trying to wind down a little bit, but I'm thinking I will continue to get calls from old clients who need my help, and I'll keep practicing. So I keep my malpractice insurance policy up to date, but I'm not sure, other than being able to find a true successor, who can take over my practice. I know there's no easy answer to this, but any thoughts on ways to address it would be appreciated.
Well, I certainly am empathetic to what the person has said, to the point where I was phasing down and then I phased back up again. And it's very hard, especially, I think, when you know the answer. Your client calls, you know the answer, you can assist them without a lot of concern or research. Yet at some point you're stepping beyond. I go back to my comment to Beth. Pick a date, and you got to pick a date. I haven't picked that date yet, personally, but you got to pick a date, and that's the date you got to live by. Because if you truly are going to try and have a foot in each stream, you're just begging for trouble, because you're going to question the insurance, you're going to question whether they have an active license or an inactive license. And so the best you can do is pick a date, and then you got to live by that date. I think there's a lot of lawyers who are kind of have a foot in both streams, and And they're really not concerned that much about malpractice insurance. What they're concerned about is having to take 30 credits every 2 years of CLE. That is another consideration. Not necessarily the cost as much as the time commitment and taking things that you want to take that you're interested in. So there isn't a good answer other than I think everybody will reach a point where they pick a date, and then that's the date that they move on. Spouses, both male and female spouses, want that date sooner than what the lawyer's willing to put it at, but that's what you have to do.
I might also interject, and the book talks about it, and Dean, you talked about it a little bit. I think one of the other issues is really just our own identity. If we've been doing this for a very long time, it's very hard to think of ourselves as not being lawyers. And so that continuing to answer questions has as much to do with continuing to feel like you're knowledgeable and engaged in your community and helping people as it does with actually clients needing you. And, you know, I will say, having started thinking about this transition, thinking about other things that one might spend one's time on is an important part of that transition, because when you can find things that give you value and are energizing to you, it's probably a little bit easier to let those things go and to help. You can help people by saying, you know who'd be great at that? This person down the street. It's hard, though. It's hard.
I agree. And all right, Dean, I'll pick a date. And I will have that date, but the reality is that date might never come. And personally, I have some things that outside of law that are very important to me, and I am not willing to put them off for a date that might never come. And that's one reason why I'm a solo, because I have that flexibility in my time to pursue these other things and fit them into my life as it exists today, and not necessarily wait for an uncertain future.
Yeah, and having served in a very small firm and truly appreciating the flexibility that offers, that affords you the opportunity to continue forever. But if you're going to continue forever, recognize you got a foot in each stream, and you just got to live with that, which isn't a good answer for the person raising the question, but it's probably the reality.
Well, thank you to all of our panelists this morning. Our second panel will begin at 10:30, and then we're going to focus a little bit more on the mechanics of how transition happens, the ethics around how transition happens, and circle back to our malpractice insurance and how that factors into the transition that we make. We'll see you at 10:30.
All right, we are back. Thanks for staying with us this morning. Before I introduce our second panel, I just want you all to know that you will receive an email with an evaluation form on it. We would be thrilled if you would fill that out for us. It also has a question that asks what future topics you would like us to cover. And so we always want to hear from you. It helps us plan for future programs. So if you could fill that out, that would be great. You will get that following the program. Our second panel. Linda De La Mora is on our second panel. She joined Von Briesen and Roper as a shareholder in 2015 from the firm of De La Mora and De La Mora. She is a member of the business practice group at Von Briesen. Her practice focuses on estate planning, trusts and estates, trust administration, probate, marital property law, and residential and commercial real estate transactions. Linda is a member of the State Bar and the Waukesha County Bar as well. She is a current board member of WILMIC. Linda is also a contributing author of our Succession Planning Guidebook. So Linda, welcome, and thank you for being with us today. Also on the panel, Aviva Kaiser. Aviva is Ethics Counsel at the State Bar of Wisconsin. Prior to joining the State Bar in 2013, Aviva taught at UW Law School for 25 years. She taught professional responsibilities, ethical and professional considerations in writing, problem solving, and risk management. From 1992 until 2002, she was the director of the Legal Research and Writing Program. Aviva received her BA in Chinese from the University of Pittsburgh and her JD from the State University of New York at Buffalo Law School. And Aviva also was is a contributing author in our Succession Planning Guidebook. And the third panelist is Katja Kunska. Katja is president and CEO of WILMIC. She joined WILMIC in 1989 as head of the claims department and held that position until 2004 when she took over as president and CEO. Katja served for 7 years as a member of the ABA Standing Committee on Lawyers' Professional Liability, and Katja, too, was involved as a contributing editor and author in our Succession Planning Guidebook. So a terrific second panel, and I now turn it over to moderator Michelle Benke.
Thank you again, Tom. So for those of you viewing the program, there have been some questions. We've referred to the winding down considerations for exiting the practice of law book. If you email, that's different than the handouts. If you email Tom Watson at tom.watson@wilmic.com, he will send this to you. He has promised. We will hold him to that. This morning, we started our conversation with our panel about how you decide and the kind of, I'll call it more theoretical conversations that one would have with oneself about transitioning. Our second panel is going to be a little bit more hands-on. And we're going to start with Aviva Kaiser. And I love the title that she has on her materials, Eat Your Vegetables. Aviva is going to take us through some of the ethical implications and the rules of professional responsibility when it comes to transitioning your practice, be it walking out the door or sale or merger or any combination thereof. Aviva?
Right, so I think today we're going to start with mergers, and we'll talk about those ethical obligations. I will warn you in advance, my slides are text-rich, which means there's lots of words on them. But the rules are important, so I like to have those in front of us. So first of all, when we talk about merging, we want to make sure that we differentiate between merging and selling a practice. So selling a practice is governed by Rule 1.17. Mergers are not, so we want to be really cautious about that. So when we start thinking about merging, and I know Linda's going to give us a lot of information about that, we should really think about confidentiality and conflicts and then restrictions on the right to practice. So we're going to start with confidentiality. Excuse me. So first of all, we have to be really cautious. Remember that when you first start those negotiations, all information relating to the representation of the client is covered by Rule 1.6. And so that means lawyers, unless they meet with one of those exceptions, are not permitted to disclose information. Now, we have a wonderful rule, excuse me, And that's SCR colon 20 or 20 colon 1.6 C6. And that rule states that a lawyer may disclose client identity to detect and resolve conflicts. Sorry about that. But lawyers have to be really cautious because they can't disclose any information under that would be protected by attorney-client privilege or would otherwise prejudice the client. So that's the first thing we have to know. Keep in mind that this rule differs from the ABA model rule. The ABA model rule is actually limited to when a lawyer is either changing practices or selling a practice or merging a practice. But our rule actually permits lawyers within the same practice to disclose client identity to detect and resolve conflicts. So again, but remember that C6 doesn't give us permission to disclose everything about the client. It only gives us permission to disclose that identity, and we can't even disclose identity if it's going to harm the client. So one of the things that we want to be careful about is that when we disclose client identity, we want to make sure that that doesn't harm the client. So if you look at that ABA comment paragraph 13 that follows the rule, it has 3 instances in there which even disclosing identity of the client could actually harm the client. So for example, if a client hasn't been charged with a criminal case, but you know that that client is talking to a criminal defense firm that does certain kind of work, that might harm the client. Or if in matrimonial cases, family law cases, if a client does not know that the spouse has filed for divorce, disclosing that client's identity, especially when there may be domestic violence involved, could in fact harm that client. And the other one is mergers and acquisitions. So when somebody's represented by a law firm that does mergers and acquisitions, probably should not disclose that client's identity. But again, err on that side of protecting confidentiality. All right. So one of the things that we suggest is that parties to that merger really flesh out conflicts beforehand. And I think, Linda can probably give us a lot of information on how to do that. But keep in mind that if in that merger, that if the purchaser wants or the other side wants more detailed information regarding that client's file, you need to get client permission for that. So one of the things that we've learned is under Rule 1.17, which is the sale of the law practice rule, that does not apply to mergers. So, and there doesn't seem to be any similar rule for mergers, so there's no consent needed by the client to a merger. But one of the things that's really important is if you're going to disclose a client's file, then you still need that consent from the client. And the reason for the difference is that, and one of the things I put on the slide, the distinction is when you sell a practice, you're ending that practice. And so when you're merging a practice, the client still doesn't suffer the blow of having to form a new relationship. One of the things that some of the ethics experts, when I was researching this, I found that they thought it was a good idea for merging firms to notify clients, even if not required by the ethics rule to do so. And when we get to the selling of a practice, you'll see, we'll talk about those notifications. But also, the experts recommend having that confidentiality agreement between the firms. So our duty to communicate with clients. We looked at confidentiality. Let's talk about duty to communicate with the clients. We do have that duty under 1.4a to promptly inform our clients when their consent is needed. But there's no consent needed here, so that probably there's no real need to do that. However, and I know I'm referring to sale, but oftentimes we find on the hotline is that client or lawyers sort of do a hybrid between a sale and a merger because they're not sure what they want to do. So we want to keep those really separate in our mind. But under that 1.4A3, we really need to keep our clients informed about the status of the matter. So you want to ask yourself if that merger comes into play there. Also under 1.4b, we have an obligation to give our clients information so that they can make an informed decision about representation. It may be that some of our clients, if they're in a smaller firm, merging with a larger firm, may not want to be a part of that larger firm. They may have liked those small firm atmosphere. So we want to make sure we comply with that rule as well. Conflicts of interest. There are so many questions here. I won't go through them all because I think Linda's probably going to go through some of those. But I've listed there on the slides a number of the questions we should really ask. And you may want to add to those questions based on the type of practice you have, because your type of practice may have other concerns as well. But again, you can see here some of the questions. All right. Restrictions on the right to practice. Keep in mind that Rule 5.6 prohibits a lawyer from offering or making, whether it's a partnership, a shareholders agreement, operating agreement, employment agreement, or other kind of agreement that would restrict the lawyer's right to practice upon the termination of that relationship. It doesn't seem to apply here when you're merging, but a lot of experts really recommend that you should include in that agreement a stipulation that if a merger does not occur, neither firm will actually attempt to recruit lawyers from their other firms, because that's usually referred to cherry picking as well. But you want to draft those clauses really carefully so you don't violate that rule. All right.
So Aviva has laid out some of the ethical rules that are applicable when we consider merging a practice, but we have in our midst someone who's actually walked the walk. Linda, you and your husband merged into a fairly good-sized firm of some renown. Can you talk to us about what it was like? When did you start? How long did that process take? And particularly some of the conflict issues that Aviva raised. How did you tackle those as you contemplated that merger?
Certainly. When I graduated from law school in 1984, my husband and I were in our late 30s. I had taught school and been a real estate broker, and he had started his career in the district attorney's office and been legal counsel for UWM, but was in private practice at that point. And we thought about our options, and advice against the advice of virtually everyone we spoke to, we decided we wanted to practice together and have our own firm. People said husbands and wives working together, it's just a recipe for a bad situation, not good for the marriage, not good for the practice, but here we are all these years later without a problem. But we've been married for 10 years and we were comfortable that it would work. My husband's practice was different than mine being estate planning and real estate, and his principally municipal law. And it worked out quite well. We had a number of associates over the years. Usually we would have law clerks from Marquette and Madison who'd be with us for the summer or during the semester, and we'd hire them as associates and anticipated that sooner or later we'd have someone who'd be interested in becoming a partner, interested in continuing the practice after we retired. And over the years it just didn't happen. Whether it was the evening meetings that my husband went to continually in the municipal law practice, or the wonderful people who I worked with in estate planning who had families and just didn't want the burdens of managing a law firm. There just wasn't anyone. And there'd be people who would move on to the corporation counsel's office or a larger law firm. We just got to the point where we realized when we were 60 that we just weren't going to have someone coming from within our firm. And we did not want to close down the firm and abandon, as we felt it, our clients and our staff. We had friends, very good friends, who were physicians who practiced together. We would compare notes, and about this time, they were closing up their practice. And we saw them really going through a lot of stress in terms of letting off their staff, trying to sell all of their equipment. They had the same kind of file issues, interestingly, that we did, where they had to keep their files for years and years, and storage and maintaining the files. Very similar. We thought we don't want to be in the same position that they were in, And then about that time, in the office we were officing in the building, there was an attorney who passed away, an older gentleman. I don't think he'd made any particular plans for succession, and we started getting knocks on the door, people who wanted assistance, not in our area of practice, but looking for their files, and not a good situation. So we decided it was time that we do something more proactive about it. So we decided what we would do would be look forward as to a merger situation, or selecting a firm that we would want to join with. And just continuing on that, my husband and I both made out lists of different firms that we thought we would enjoy working with. We are practicing in Waukesha County, and so we mainly stuck to Waukesha County. We were looking at smaller firms that where we knew people that we thought we'd enjoy working with them. So we compared our lists, we started narrowing things down, looked at pros and cons, looked at areas of practice, whether the fit would work, locations, whether that would work for our clients, work ethic, reputation, all those things that you think of. And we pulled out a few firms that we thought we would talk to, and we chose who would talk to them, and we set up a few meetings. We met with several firms, and had and very interesting, found out different methods of compensation, different attitudes, but didn't find just the right fit initially for us. And then one firm on his list, on my husband's list, was the Von Briesen firm. We had known a lot of attorneys there. They were downtown. They were a larger firm. We didn't initially think about that type of a situation, but as soon as we called one of the senior partners that we knew well, he was very enthusiastic, said the firm was thinking of expanding into Waukesha County. It was just the right time for the firm to talk to us about it. We went downtown, met with a senior partner and a few other people, and it was love at first sight. It was just something where we could see that what they were looking for and what we were looking for sounded very compatible. My husband's area of practice, being municipal law, was something that didn't fit in a lot of firms, but Von Briesen was expanding their government law practice, so it was just a natural there. Von Briesen had a large estate planning group, both in Madison and Milwaukee, and expanding into Waukesha County was a good fit for them, and so we were very enthusiastic that we'd found our plan.
So, Linda, the first date went well, and there was champagne and canapes, and people were making googly eyes at each other. But to actually merge a firm, it seems to me you kind of have to get past what's your favorite album and really get down to kind of brass tacks. Can you talk a little bit about when and how you started talking about what it would actually take to merge? And I'm guessing that a lot of that would focus on some of the last part that you talked about, which is Von Briesen getting a handle on the size of your practice and the nature of your practice and who some of your clients are or were. So talk us through how those discussions went and the disclosure and the confidentiality rules.
Well, the next thing that we did after we had the initial meeting and saw that both sides were quite interested is we drew up a confidentiality agreement and laid that out, and both sides signed it. Then we provided the Von Briesen firm with several years of our financial information. We gave them information about our claims history, which we didn't have any history, fortunately. We listed all of the assets, computers and copiers and pictures on the wall, and everything that we had. We wrote out a description of each of the attorneys in the firm, when they joined us, what their salary was, areas of practice. We listed all the staff that we had, from bookkeepers to legal assistants, when they joined us, what their salaries were. One of our offices we owned. We had another office that we had a lease for. We provided them with the lease for that office and information on the office that we owned. And gave them all of that information. We discussed with them how their partners were compensated, how they would compensate us as partners. We found out that for our staff, their practice was when someone joined, they would give them a higher salary than what they had, so we knew that that was something that would be of interest, we thought. We talked about the plans for their office in terms of their thought was that we would stay in our 2 offices for a period of time, and then ultimately we would merge into a larger office that they would be setting up in Waukesha County, and we talked about location. We covered everything that we can think of that would affect us, how our legal assistants would be continuing to work for us, because that was important, and really got to the point where we were comfortable putting together a memorandum of understanding. We had a good understanding of timing and what their intent was, what our intent was, and so then we put that down as a memorandum of understanding.
And as you reached that memorandum of understanding, what level of disclosure were you making to clients? Did you say, hey, we had a first date, or hey, we're engaged, or did you wait for the full execution of that memorandum?
We told no one. We didn't say anything to clients. We didn't say anything to staff. We really didn't feel that at that point we wanted to rock the boat, so to speak, and start talking about things that hadn't happened. So, but the next thing that was important was to do a conflict check to make sure that that wasn't going to be an obstacle, because there could have been a situation like that where we had major clients in conflict where it just didn't make sense from either firm standpoint. So we were able to put together a listing of all of our clients going back to before 1984 to my husband's practice, and they, Von Riesen had a very good system where they ran it through the computer. We saw all of the conflicts, and by and large, it wasn't as big an issue as we feared. My husband's governmental clients, tended not to show up on their list. Mine were mostly individuals, a lot of them in Waukesha County. The biggest issue was that the John Andersons that would show up on both lists. Von Riesen had a lot of national law suits with many plaintiffs and defendants, and so all we had to determine this was John Smith in Boston, not our John Smith, and so we got through the conflict check, and then at that point we basically said it's a deal, and the next step was sending out letters to our clients. They wrote the letter, we edited the letter, and made sure we were comfortable with it. We explained to clients that we were terminating our law firm and joining the Von Riesen law firm, and that we'd be happy we were continuing in practice. We'd be happy to have them continue as our clients if they wish to do that. But we gave them some information about the firm, of course, refer them to the website. But we indicated that if they wished, they could pick up their file or we could send it to another attorney. We found that the clients were very receptive and interested. The biggest problem we had was we just had a rush of sending out all these letters. People just wanted things done yesterday, and so we were busy thinking about getting everything taken care of on the merger, and all these clients who were, now it's time to update my estate plan, just when I wasn't looking for all these matters to come to a head. And there were the people who didn't quite understand, and no matter what the letter said, they figured we were retiring right away, and we had to say, no, that wasn't the plan. But and so there was a lot of explanation that way. But I would advise anyone word the letter very carefully and be ready for the onslaught of responses from people.
Katja, so we send out this communication to clients, and as Linda mentioned, everybody jumped to and decided they needed to get X, Y, and Z done. I could also envision that might cause a client to pick up a file or look at their estate plan or some of those things. And in our first segment, we talked about the statute of limitations. From an insurer standpoint, is there anything about that disclosure to the client about the impending merger? Is there something that the insurer would like to be in that letter or would like not to be in that letter, so as to not encourage people to suddenly go, here's my last kick at the can, and maybe I need to take a look at what this lawyer did for me?
That's an excellent question. Merging two practices is merging your liability. So I think, from the insurance perspective, conversations need to be had long before the point in time where the letter goes out. You need to know what the firm you're merging with has in terms of insurance, the limit, the deductible, and specific kinds of coverages. I would also look at the definition of a insured lawyer, because in some policies it's any lawyer who's ever worked at that firm. In other policies it is only lawyers who are currently working at that firm and whose name is on the application. So that will make a big difference. In terms of liability, what you're responsible for makes no difference. You're responsible for everything you were responsible for before. It's just that you're sharing those. So now, if you merge as a partner, you take on responsibility and liability for the bigger firm's work. If you come in as an employee, you probably do not. You are responsible for your work going forward. So it's something to think about. If you are coming from a small practice and you're going into a large firm that does a whole lot more areas of practice, do you want that responsibility? If they're, the point of insurance, in my view, is to protect your clients and to get them where they should be, but for your mistake. So when I am asked how much insurance should I buy a new lawyer, it has nothing to do with your assets and liabilities, and the fact that all you have is law school debt doesn't mean you shouldn't have insurance, because what you're protecting is the client's work. So if you will do work, if you will do real estate transactions and estate plans and criminal defense, and you're in a less urban area of the state, $100,000 policy, which includes defense costs, might be perfectly adequate. You get the smallest deductible, $1,500. It works for your clients. If you merge that practice with another firm that is doing $500,000 things, your clients are still protected. But if you come into that firm and a claim is made, as Joe explained earlier, because the policy covers the date the claim is made, not the date you do the work. So if you come in as a partner and you take on the liability of the big firm that you're merging with, you might be exposing more than you thought you were. So you really need to understand your own coverage, what you're protecting, their coverage, what they're protecting, and see, as Joe explained, you can do this with a tail endorsement that protects what you used to do, with a retro date that protects what you're going to do. But you also want to think about who you are when you come into that firm, and what exposure you have, and then what insurance you can get for that exposure. Because exposure doesn't equal insurance. Liability doesn't equal insurance.
So let me follow up on that as well. I think of my clients working on various business transactions, and somebody has liability insurance, and somebody else landlord has liability insurance, and the tenant has some liability insurance, and then something bad happens. And what everybody is always worried about is this is your coverage. In a merger, what kinds of things ought people be thinking about in these various allocations, and how should somebody go about thinking about making sure that you don't end up with insurance companies going like this?
Right. If you have a very specialized practice and you have clients all over the world, we heard Beth Russell talk about that. A firm, if she were to merge her practice with another firm, they're going to take on an exposure they may not have had before if they give Beth full prior X coverage. So if you want to keep it separate, if it's cleaner, safer, better, then you need to insure, to a certain date with the correct amount of insurance, with a deductible that you can afford, with coverage that you asked for. So you can extend the point in time in which a claim is made up to forever, but you can buy a tail for as short as a year. So you need to understand that, because the statute of limitations for claims against lawyers is 3 years, but it's 3 years from discovery. So we can tell you that 80% of our claims will be made within 3 years of the date a lawyer does work, but the liability goes, it can go a very long time. If you draft a will for a young person and they die 60 years later, and their family discovers that you forgot to mention the closely held business, or you missed a kid, they can make a claim for 3 years from the date that will, the disenfranchised beneficiary discovers they should have inherited something and they don't. The oldest claim we had was 28 years after a lawyer did some work. He helped a client buy a piece of land. The client said, when I retire, I'm going to build a hunting cabin on this land. And so the rural piece of property sat there for 28 years. And then the client retires, goes to pull a permit to build the cabin, and discovers that there's an easement from the DNR that says you never get to build on this land. So the claim came in to us. We still insured the firm that the lawyer worked for. The lawyer was dead. The file was MIA, but the liability was there, and thankfully the insurance was there. So 3 years from discovery can be a very long time. So you need to think that through, and which coverage you want to point in which direction.
So sounds like another item on our to-do list as we're thinking about transitioning, and you can't just assume that a new firm has coverage and all will be well.
You might not want new firm to cover your past work. New firm might not want to cover your past work. You might, if it's two different carriers, you might, if you have an option of getting full prior X coverage or starting with a retro date. You need to understand both sides of the coverage issue, both insurers, both sets of limitations and opportunities, and then decide what works best for your clients going forward, and for yourself, of course.
And I'm going to bounce down to Linda.
Yeah.
How did that discussion go, and how much time and energy in the whole merger did you actually have to spend on that issue?
That was probably the easiest part of the merger. We found out that we would have full coverage once we started with Unbriesen under their policy, and we were very comfortable with that. And we made the call to WILMIC. We were policyholders since the inception of WILMIC and knew the personalities, and spoke to George, who spoke earlier, and chose, especially as a state planner, I knew that I wanted full prior X coverage, and so easy decision to make, and wrote out the check and slept at night knowing that we had the WILMIC prior X coverage, and we were fully covered going forward with the firm we merged with.
So we started out with merger, but sometimes lawyers envision selling a practice, and that might be, as you said, Linda, the idea that there's somebody homegrown that can be your succession plan, and while you may like that person and wish them well, most times we don't just say congratulations. So there is some compensation in selling that practice. Aviva, do you want to take us through some of the issues related to sale of a law practice?
Sure, thank you. So we'll start with the rule, because as I put there, it's often the most misunderstood or overlooked rule, right? So the very first thing is that the seller, the lawyer who's selling the practice, must cease to engage in the practice of law, either in that whole practice or in the area of the practice that's been sold, or in the geographic area or jurisdiction. So we're going to unpack that, because there's two things going on: that you can sell either the entire practice, or you can sell an area of the practice, and you're required to stop practicing either in the jurisdiction or in the geographical area. And then the second thing is that entire practice, as we said, or the entire area of the practice must be sold. So one of the things that we learn about selling that practice is that if that lawyer makes a good faith effort to sell the entire practice or the area of the practice, you're not going to be barred from that if clients disagree, right? So if there's clients who decide not to be represented by the purchaser of the practice, that's not going to stop the purchase. It just means it's not a violation. They can take their file and go elsewhere. The ABA comment, paragraph 3, tells us that a lawyer who sells the practice can engage in practice of law, for example, at a public agency or a legal aid agency or in-house counsel. They just can't engage in the private practice of law. So there's an ABA opinion from 2014, right? It's 468. And that opinion clarified what it meant to cease practice. So that opinion does permit a lawyer to help with the transition. The opinion's interesting because it doesn't put a time limit on. There's other opinions from states that say 6 months to a year, but this ABA opinion doesn't. It does permit the lawyer to help with the transition. And in addition to that, clients can't be billed for that transition. So, yeah. Now, one of the things that in a large state, or a large jurisdiction as they like to call it, there might be a way to segment a geographical area so that you can sell your practice for that area, but then move to another area. I don't think Waukesha and Milwaukee would work, but in other words, if you have a large state like Montana, for example, and you're selling your practice in one area of the state, that's fine. And then the other part of that is that if you sell an area of the practice, so the example that the ABA comment gives is if you sell your estate planning part of the practice and you keep your estate probate practice, that's fine, you can do that, but you just cannot take any more estate planning clients again. And that also means that when we look at that 1.5E3, a division of fee, you want to be careful that you don't take on a referral case that allows you to get referral fees on an estate planning case, because that would violate the rule as well. And I think we have that there. All right. So one of the things about the sale of the practice that's different from merger that we saw is the notice to the client. So we have to give our clients notice here about the proposed sale, and then the client's right to retain other counsel. The rule doesn't tell you when that notice has to be given, though. So it might be interesting to think about how soon the client should be told that this sale is going to be anticipated. And again, from the ethics rule, it doesn't require that, but I think it would be really hard to wait till the last minute, and not in the merger, but in the sale part of it. The good thing about this rule is if you can't find a client that you have to give notice to, one of the things you can do is it won't stop the sale, but you should get a court order that says you can transfer the file at that point. Wow. Yeah. Because there's no one to speak for transferring the file, and selling that practice is giving that file to somebody else. So you want to be really careful with that. So one of the things that we look at confidentiality as well, and it's the same to some degree with mergers, right, is that 1.6 covers all information relating to the confidentiality or to the representation of the client. That 1.6C6 permits that lawyer to disclose client identity, but really nothing else. If that file is going to be transferred, you do need client consent for that. One of the nice things about this rule is if you don't hear from the client within that 90 days, you can transfer the file once that client's been given notice. And again, it doesn't change the client's right, their absolute right to fire the lawyer. All right, and then we talked about no fees. You can't charge those fees by reason of the sale, but you also can't increase your fees. So keep in mind that your engagement agreement with that client still stands. And then I just want to make sure we got everything here. Oh, yes. So I knew I wanted to add this. I added this when I was thinking last night, is if a client or a lawyer dies and we have to sell that practice, or their spouse is going to do that, the buying lawyer is bound by the rules. So even though the spouse or significant other or a child selling that practice isn't bound by the rules, the purchaser is. So there's that protection there as well.
So, Aviva, one of the things you talked about was the lawyer who's selling the practice has to cease practice. Mm-hmm. And earlier this morning, we talked about how difficult it is for some lawyers to really let go. So I could certainly envision that scenario in which you go to longtime client and you say, I'm selling my practice, and they say, congratulations, but I'm not going with them. I don't need you on a daily basis. I just need to consult with you here or there. I like you as a sounding board. You always had such great judgment, and you know us so well. And there's just no way I'm going to get somebody else up to speed. And by that point, the hook has been set, and lawyer is certain that they have to remain available to this client. Can you talk a little bit about what happens if the lawyer goes down that road?
It's violation of 1.17.
So you can't be a little bit sold.
Well, and that's the problem with this rule, that a lot of lawyers didn't understand that. And when you're selling that practice, clients don't belong to anybody. But when you sell that practice, and there's that expectation that now those clients are going to go with the purchaser practice. And then all of a sudden you say, well, this guy wants to stay with me, and this guy wants to stay with me. All of a sudden that, violates the rule. So you want to be really cautious there.
So now I'm just going to dig a little bit further, because you also talked about being very cautious about non-competes or other restrictive elements, and at least based on my experience in the business world and sale of businesses, non-competes are pretty typical, and people expect those kinds of things. And one of the places that the law does not favor the non-compete is things like medical practice or law practice, because they value the client relationship, and it is so unique and special that they believe that the client ought to have the ultimate right to make their selection on who they get that service from. Can you talk a little bit about whether any discussions within the rule about how those two things get balanced?
Well, I think the way they get balanced is that lawyers have a lot of flexibility in how they end that practice. So they can merge, they can cut back and keep some of their clients. But when they sell their practice, they make that commitment to the purchaser of the practice to sell that entire practice. And the nice thing about this rule is it really makes it very clear the lawyer can't continue to practice. And when you look at, and it clarifies that Rule 1.6 on restrictions of right to practice, right? Because normally we know you can't restrict that lawyer's right to practice precisely because you want to make sure clients can choose the lawyer that they want. But what this rule does is balancing those concerns, say, all right, lawyer, it's not a restriction on the right to practice. You just can't continue to practice once you sell.
And I'm going to go one more time. So when I first started practicing in the business world, doing those business transactions, we did often have a non-legal practice. We do non-competes. Mm-hmm. And, the non-compete had to have a time limitation, it had to have a geographic limitation, and it had to kind of describe what competition was. But here I am 30 plus years after law school, and the world is different. And especially after the pandemic, and we learned that we could all work from virtually any place, mm-hmm. right? So how do you square, or how does that ability to work from anywhere? I sell my practice in Wisconsin, and I move to Hawaii. Mm-hmm. That doesn't really prevent my former client from emailing me, right? So how do you think about those kinds of changed parameters when you think of selling your practice and adhering to that rule.
So one of the things we learned with the pandemic is the rules don't depend on where you are. So, whether it's you're communicating by email and you have to be safe, or whether you're having hearings by Zoom and you have to make sure you don't get Zoom bombed, right? It doesn't matter where you are. You're still bound by that rule. So if I move to Hawaii, and I'm a Wisconsin lawyer, I'm bound by that rule. And I just have to say, I'm really sorry, client. I can't do it.
Unless you were doing estate planning in Wisconsin. You sell your Wisconsin estate planning practice, you can go to Hawaii and have a new estate planning practice, correct?
As long as you don't violate the unauthorized practice.
Well, yeah, assuming you're licensed in Hawaii, right? Assuming that your Wisconsin clients aren't, contacting you every 5 years saying, update my plan.
Right.
But you can go to a different jurisdiction and start a new practice.
Right.
In the same area of law.
So, Beth, you can sell your practice here in Wisconsin and go back to New York and practice all you want.
We
got a question.
Yeah, we have a question from the audience.
We do. A viewer wrote in, when I want to close down my practice and I start notifying clients, how far back should I go to contact old clients? Every client I ever had? Only those over the last 20 years? 10 years? How far back should I go?
So the duty of communication under 1.4 applies only to current clients. It does not apply to former clients. Then what you're going to look at is what kind of practice you have, because if you have estate planning practice, you're certainly not, you want to let those clients know. If you have a criminal practice and, there I don't think former clients probably expect, unless they're long-term clients, but we don't go there. But anyway, but again, it's going to depend on the type of practice. The thing I would suggest is clients that may be 3 or 4 years that you think so in family matters, right? Post-judgment, those clients you may want to let know. The question becomes, how do you let them know as you found out about their files and what's going to happen there? And so oftentimes lawyers will post something in newspapers. They'll take out an ad that says, we're closing. I don't know how many people that reach. So I would probably look at my files and say what kind of practice it is. Well, I'm going to go back 3 or 4 years and say, this is a courtesy. I know I haven't seen you, but I'm closing my practice if you'd like your file. We have that file opinion, EF-16-03, that says we're required to keep that file for at least 6 years. And that's the floor. It depends on the type of practice. So estate planning, again, you're probably going to keep them forever. But, and you also want to check with your malpractice carrier. Some of them require 10 years rather than 6. So keep in mind that it may be you'll want to go back and notify some of those former clients that are closer in time. But there's no obligation.
And actually that raised a question for me, because I remember attending another WILMIC seminar that talked about file closing letters, which up until that point, I was probably like most other lawyers. I never actually wrote a letter to say, hey, we're done. I have completed your matter and I no longer consider you a current, because the nature of practice, we want our clients to continue thinking of us as their lawyer, et cetera. Right. So Katja, what would your advice be in terms of the kinds of notice that we might, that you as the insurer might recommend that we consider?
For selling a practice.
We're
limiting this to selling a practice.
Yes.
I think closing letters are terrific because the existence of an attorney-client relationship is subjective in the eyes of the client. So just because you think they're no longer your client, that won't matter when a court is looking at the issue of, does this client have a reasonable belief that you continue to represent their interests? Mm-hmm. So a closing letter says, I'm not your lawyer anymore. Even if you're, I did an estate plan and I told you to update it every 5 years, I have not committed to doing that for you. I have just told you this is something that you should do. I'm done giving you legal advice. It's very helpful for claims defense if something happens 5 or 10 years later. I think if I were a working in a firm, considering merging practices with other firms or other lawyers, I would look very hard at their practice on closing out representation.
I mean, it's really crucial in terms of, for example, in estate planning, what if you don't send that closing letter out and the law changes dramatically?
Right.
And now all of a sudden, you know,
Right. A client could testify that they reasonably believed, because you advised them on estate planning law at the time you did their will for them, that when the law changed, you were going to let them know that they had to change their will or their testamentary plan, because the outcome would be different. And they told you what the outcome was that they wanted.
right?
And so I could see a client making a successful argument. And if you're just saying, no, I said goodbye. Goodbye means goodbye forever.
Well, especially if you send out those bi-monthly newsletters you know.
I was going to say, I got in the habit of sending the closing letter.
Yep.
I probably shouldn't say this in front of my insurance carrier. But then I also have gotten in the practice, when various components of the law change, I do generally send out some little, hey, did you know? So when the power of attorney statute changes, or when the estate exemption level changes, I send those little, but I don't write dear client. I do say, hey, did you know?
Dear world.
Dear world.
I think that's fine. I think that's fine, because the closing letter is specific to that client. Your newsletter or your general legal information is, dear world, dear everybody. Yes, it will get confusing if you write dear client.
And it will get confusing if you do it all the time.
And construed, of course, in their favor when they testify that they were relying on you to say, oh, and by the way, this change specifically affects you, and your plan no longer works for its intended purpose.
And another good reason to send out those closing letters is because it converts that client from a current client to a former client. And the rules for conflicts are so much stricter for current clients. So you can have direct adversity for current clients in totally unrelated matters, when that wouldn't happen with former clients. So just be really cautious there.
But I do want to add that just because you're no longer their attorney, it does not mean you no longer have liability for mistakes you made when you were their attorney. So selling your practice, writing closing letters, notifying clients that you've sold your practice, the liability goes with you. What you need to do is make sure that the insurance coverage for that liability also goes along with you. So if you have what we call a long tail practice, real estate and estate planning are two really good examples where a client may not know for 10 or 20 or 30 years that you did something that, it turns out less than they wanted. They can sue you. So if you had that kind of practice, our advice would be that you make sure you do buy the extended tail endorsement that goes forever, because you don't know when those claims will come. If you have a criminal defense practice, I think a 3-year tail is plenty good.
So Linda, you talked a little bit about going back to the merger kind of communication. You talked about the fact that Von Briesen wrote a letter and that you did some editing. Can you just give us some high-level issues that you that were discussed in that letter? Because I could also see, as clients getting this, and you're walking this balance between, hey, we're merging, but we're staying, but your matter can go with us, but somebody wanting to maybe exit stage left. What were the key points, and how did you kind of reach agreement on that letter?
It was really a one-page letter, so it wasn't like it covered everything they could think of, but just to provide them with information that this was our transition that they could make with us if they chose to, information about the firm, information about where we would be located in the near future. And I don't think that, we really covered much more information than that. In terms of file transfer, that was certainly something we had to discuss and do it with Von Briesen quite a bit. And basically only our active files transferred to Von Briesen with us. However, we had all our files from 30 plus years back. And so with a practice like estate planning, things keep coming up, and I get calls, every week and maybe every day, someone's died, someone wants to update their estate plan. So every time that happens, I pull out the De La Mora file, run the conflicts check, and it gets opened up as a Von Briesen file, and that's how we handle it. And usually clients are relieved to find me, and even though I'm in a different location with a different firm name, they're just pleased that there's somebody right there who they know who's ready to continue with their matter. So that has worked out quite well.
So, Linda, you brought up a great point, because we get questions all the time from lawyers calling who've moved and merged their practice, and now they're retiring, and there's a whole issue of where their closed files, because they thought their closed files was going to stay with that firm. So they moved their closed files to the firm because they were still working on clients, especially in those long-term matters. And now that they're retiring, the firm said, you got to take those files with you. And there were a lot of files. So,
and the challenge with files, of course, is we had paper files all those years back. There was no such thing even as a computer or copy or email, things like that. And so we have huge files. And so when we go to reopen them now, it's a lot of scanning and culling things down, and it's a time-intensive process both to store those files and to reopen those files. But that's the nature of the beast.
So Aviva, let me ask you this. So let's say, Linda's situation is perfect as an example. So some files from her firm came to the new firm. Some did not. So when Linda does retire, I assume that the De La Mora files continue to be your responsibility. So could Linda take those to a UPS office and say, scan these paper files for me, pay the fee, have them sign the confidentiality agreement? Because in litigation, you can have, a third-party copy service copy your file as long as you tell them not to shout about it, right? Could she do that so that the paper files are at least at least you could put the thumb drives in a shoebox?
So here would be my concern about going to UPS. I don't know if they could sign the agreement all they wanted, right? But if they're out in the open copying those files where people were walking by, so you'd want to make sure, do your due diligence when they copy them. Do they keep them safe while they're doing that so that other people aren't around? Then the other thing that you want to worry about is if they're using copier machines that have hard drives, then that information is stored on those hard drives. So you want to, just like when you're getting rid of equipment, when you're closing your office, you want to be careful about that as well.
Well, and that was this issue of the file transfer is a big one. My office is being relocated, and just for logistics, I'm trying to figure out how many boxes and where we're going to store them. So we've internally started that file scanning process. But if your client, either in a sale or a merger, elects not to go with that new firm, and you are going to turn over that file, what are you turning over? Are you turning over the hard copy? Are you turning over the thumb drive? What are you turning over when you give that client their file?
So under our ethics opinion, that EF-16-03, we talk about returning those files. And if a client wants a file in paper, and that's the only thing they can use, then you have to give them that file in paper. But if they can use, a flash drive or, a disk drive, that most computers don't have those now.
I used to store things on CDs, and there are many laptops that don't have CDs even anymore.
I know, I bought an external CD player so I could still access things. But you're right. So in terms of turning that file over, it's really what the client needs. And the rule for that is that 1.16D, because it says you have to take all steps reasonably practicable to protect the client's interests upon termination. So what you want to do is make sure that they can use that. Along with that is some of us older lawyers, and I won't add you in there, Dean, have original documents in our files. And so before you can destroy those files, you have to go through all of them to make sure that there's no originals in there. One of the things that we recommend lawyers do in their document retention and destruction policy and in their file policy is say, look, never keep those originals in that file, because that way you don't have to search later on. That's your policy.
Right, and I think also when you scan your files, 2 points. When you scan your files, you don't have to scan the whole file just because you've got a box this full of things. Because I really don't think things like pleadings are nearly as necessary as your notes and your correspondence, the communications you've had with the client. Your carrier wants you to have your file. They don't want you to go nuts.
And
My,
so if
my
the-
assistant would probably appreciate your saying that, because as we are scanning files, being a transactional lawyer, I usually keep virtually every draft of the purchase agreement. Just so that you can see where the negotiation went.
So here's the thing about that. I'm glad, because that's in a footnote to that opinion, right? That you don't have to keep your drafts, but if you keep them, they're part of the file and have to be retained. And thank you for noting about notes of conversations with clients, because oftentimes our lawyers think that that is attorney work product and they don't have to turn over those notes. But they do, and that opinion talks about it. Anything that the client pays for, like your time where you're taking those notes, belongs to the client.
And you'll want the notes if you
Oh,
have to defend
yes.
against a claim.
That's right. Yes, two questions.
Yeah, two questions, one for Linda and one for Aviva. Linda, did all of your staff go with you to the larger firm, or did you have some employees who did not want to go to work at the new firm, and what did you do with them?
Fortunately, all of our staff came with us, and happily so, and they all have stayed with us. All the associates and legal secretaries. One legal secretary has now retired, but they were all pleased. Larger firm offered them more benefits than we did. They were trained well. It worked out very nicely.
You picked the right firm, I guess, for you. The question for Aviva, what does of counsel really mean, and what are the options on what that might look like? Not necessarily the ethics aspects, I see those slides, but in practice.
Perfect transition. I was headed that
Okay.
direction.
Oh, good. It's the eggplant rule, right? Sorry. So what does it mean in terms of practice? So a couple things come in there. Number one, you still have to have that close, continuing, regular personal relationship. There's usually a number of instances where that comes up. Number one, we're seeing it when lawyers want to retire or, sort of start to disengage. So at their firm, they'll go of counsel. So if I've been with a firm for, 40 years, I may want to go of counsel. So the next thing that comes up that we're seeing more frequently is in lateral moves, where someone will go in of counsel to sort of a look-see. Again, because of counsel requires that closeness, conflicts are, again, a big issue, because all those conflicts would be imputed to the firm. So if I'm a lawyer and I'm going into that firm for, a look-see, all my conflicts are going to be imputed to that firm, and there's mine as well. Sometimes it's done as a part-time position, so we found that of counsel may have occurred where lawyers have other obligations, and so they're only practicing part-time as opposed to retiring. They'll join a firm as that of counsel. So I think those are sort of the more practical things we see with of counsel. So Tom, was there anything else about that, like any more part of the question that was?
That was it.
That was it, okay. Well, if they want.
I've got a question for our liability insurance carrier. I hear people sometimes talk about it because they view that of counsel as perhaps different than, and some insurers treat the cost of insurance carriage different for somebody who's of counsel because they are working part-time or have lesser amounts. Katja, do you want to say some things about how liability insurance looks at of counsel?
Sure. Remember what I said earlier about who gets to decide whether an attorney-client relationship exists. that is the client's choice. And when a client sees a letterhead where one lawyer is in the of counsel place and another lawyer is in the members of our firm place, from the client's perspective, most likely they don't know that there is any limitation on liability, any limitation on exposure. So in fact, my belief is that an of counsel role with that firm from a liability carrier's perspective is the same as merging practices. You have to do the same searching for the right amount of coverage, availability of coverage, affordability of deductible, make sure that if it's it was an exclusion that was added back in, if you need title agent coverage, that you have that going forward, because you're combining liabilities. You definitely want to be combining coverages.
And Linda, when you joined Von Briesen, some firms have mandatory retirement age or points at which somebody becomes of counsel. Were there any discussions like that as you had your merger conversations?
I don't think Von Briesen has any of counsel situations, but they do have a number of senior attorneys who have chosen to work part-time and just on certain projects, and I think they have quite a few. I know there are some firms that have a mandatory retirement age, and we'd be long gone if that was the case, and so would a lot of other attorneys at the firm, but they do welcome older attorneys practicing.
And carriers WILMIC will happily consider a part-time practice and charge a part-time premium for that part-time practice. Okay. But the coverage isn't less. It's the cost of the coverage is less because, the less time you spend doing something, the less risk you bring.
And it's still prospectively based on the lesser amount of practice you will be doing prospectively. That is not the same as covering all of the full-time, fully engaged practice that you previously were doing.
And that's the bargain you get, because as you go to a part-time practice, you're still covered for the work for your policy covers against the risk that a claim will be made. And the claim doesn't have to be made within your part-time hours for there to be coverage. So the carrier takes that risk of your previous full-time 40 years of practice and puts it into a policy that looks just like everybody else's policy, except you paid less money for it. But not all carriers allow a part-time premium specifically because of that. So you need to check with your carrier.
So one of the things I want to keep separate is, for ethics purposes, of counsel's one thing that may not be the same for insurance purposes. And one of the reasons I put this in the slide is here you have this Connecticut ethics opinion that says somebody who just answers calendar calls can be of counsel. But when you think about those large bankruptcy firms that have local lawyers covering the meeting of creditors, those would not be considered of counsel. But on the other hand, back when this was written in 1999, it could be that the firm or the lawyer that covered those calendar calls would be of counsel. The other thing that, so always check your jurisdiction. So for example, sharing space, there's a definition of law firm in 1.0, and it's SCR 20:1.0. And you may be a law firm under that definition because of certain things you do, even though you don't advertise yourself as a law firm. So your conflicts will be imputed. Now, for liability purposes, that may not be the case. So, and then there was one other thing. When all conflicts are going to be imputed there as if everybody's in the same firm. That brings up legal polygamy. So there are a number, I know, I had to get that in there somehow.
And you thought this was going to be a dry and boring program, right?
Sorry, I've been waiting all morning to do that. Right? Had you not, but yeah.
You squeezed it in with 5 minutes to go.
Right, but the thing is, some lawyers, like tax lawyers, specialty counsel, will be of counsel to a number of firms, and they don't consider that. They'll say tax counsels. But unfortunately, you can be of counsel to a number of firms, but you are going to be a conflict conduit. And the conflict is not just in your specialty, it's across the entire firm. So you want to be really careful of that.
It's like referrals.
Yes.
If I refer a matter that is too big for my small firm to a larger firm, and I decide to keep a percentage of the fees, and we reach that agreement, I'm as responsible if the large firm makes a mistake as the large firm is, and my carrier will probably have to respond to a claim.
Right.
So it's similar in that regard. You can't give away, you can't compartmentalize your liability.
Right.
Well, in the last few moments that we have left, I'd like to give our panelists an opportunity to give us some words of wisdom. I'm going to start with Linda. In the merger context in particular, thoughts that you have if somebody's going down this road, some things that they ought to think about, some timing questions. What words of wisdom would you have if someone is going to explore merger?
Well, certainly one thing one has to think about if they've run their own practice, that they won't be doing that anymore. And they have to be comfortable that they're not the boss anymore and they're not calling the shots anymore. And so that's certainly something. Some things that we found out, though, was that being relieved of all the responsibilities of running the office was really something that energized us. And we merged 6 years ago in June of 2015, and we fully thought we would be retired by now, but here we are. I think we have really enjoyed having more people that we work with. We enjoyed not having to worry about billing and bookkeeping and accounting and all the things that go with making sure there's coffee in the morning for everyone and all the basics of running an office. We're relieved of that. And so that's something that we look forward to. We think back, we think, during the pandemic, if we'd be sitting at home, how bored we'd be. So we're glad that, we continued practicing, but it wasn't something we anticipated. And now, the set a date discussion earlier is something that we're still working on, is, getting that date set and deciding. But in the meantime, we've found it a very comfortable situation where we don't have to do the management that we used to. And so it only encourages us to continue practicing a little longer.
There you go. Katja, somebody's thinking about selling or merging, and one of those things is what you don't know stops you. What are some words of wisdom and advice you would give people in terms of tackling that issue of professional liability insurance as they embark on this transition?
Same thing you tell your clients, which is you don't know what you don't know. So let's either I can answer, I can tell you about this question, or I can find somebody or some source to give you the information. Very few lawyers become used to, Dean did it twice, but very few lawyers do this 15 times. So it's not something you're going to get good at, and it's not something you're going to do very often. So please, please, please ask questions. Both insurance companies. Make sure that when you are talking to, the lawyers in the a firm you're considering a sale to or a merger with, you need to be annoying if necessary, because coverage does not equal liability. You can take on all kinds of liabilities that never occurred to you, that don't even make sense to you. So if you have them, please make sure that you have coverage for those liabilities.
Aviva?
So
Don't breach the rule, right?
Right, don't breach the rule.
That's your advice. Don't breach the rule.
Right. That's a great, I'll have to use that next time. But really importantly is to think about not only the business aspect, but the rules and how they apply, because it may be that what your goal is, the rule's going to not help you meet that goal, so you're going to have to change it. And we see that all the time with merger and sale.
So that brings us to the end of our time. I'm going to do one more commercial at least. This book is a tangible first step, and not talking about it, not thinking about it, and not planning for it does not mean that it won't happen. So email Tom Watson, tom.watson@wilmic.com. He will send it to you. You can also go on their website and download the PDF if you want it today, because now that you've had the seminar, you just have to start reading. But we're all in a heightened sense that transition is one of those things that we should think about, plan for, and as Dean said, pick a date for.
And if I could give one plug, the succession planning registry on the State Bar's website. And Chris Shattuck, who's our practice management guru, would be glad to help you with that. And so would I, so you can call, and I'll refer you to Chris.
Thank you.
Michelle, thanks for putting my email address out there. I've been getting lots of folks asking for a repeat of that who want the book. So tom.watson@wilmic.com.
tom.watson@wilmic.com. Thank you very much. Have a great afternoon.
Thank you.